Today, we're diving into a question that seems pretty simple on the surface, but it's actually one of the most fascinating and complex ideas in our society. How does the law really work? You know the image we all have in our heads, right? You've got a judge, a big stack of dusty law books, and a clear set of facts. The judge just has to flip to the right page, find the perfect rule, and bam! Justice is served. It's supposed to be simple, clean, logical. But what if I told you that whole picture is mostly a myth?
That's exactly what the legal scholar Edward H. Levi was getting at. He called the whole idea of law as this fixed, predictable system a pretense. So today, we're going to pull back the curtain on that pretense and see the surprising, dynamic, and honestly, very human process that's really going on.
Okay, so let's dig into this myth. Where did this idea of law as a perfect, predictable science even come from?
Well, the fancy name for it is legal formalism. This theory pictures the law as this perfectly organized pyramid. At the very top, you have a few huge fundamental principles, and from those, you can supposedly deduce a rule for literally any situation. So in this view, a judge's job isn't to create anything. Nope, they're more like an expert researcher, just discovering the law that's already there.
And this quote just perfectly nails that way of thinking. This came from Christopher Columbus Langdell, who was the dean of Harvard Law back in the late 1800s. You have to remember, science was king back then, and Langdell wanted law to be seen as a hard science too. He argued that a law library was basically the same as a physics lab. All the data a lawyer needed was just sitting there on the shelves, waiting to be found and analyzed.
But, this is where that whole neat and tidy model starts to fall apart. What happens when something totally new comes along? A new technology, a new kind of social problem, something the original rule makers could never, ever have imagined. What are you supposed to do when the old rules are just silent? Or even worse, when the words they used are hopelessly vague?
And this brings us to the real engine of the common law. And let me tell you, it is way more creative and messy than that formalist myth would ever have you believe.
So, what's the alternative to just applying fixed rules? Well, according to that same scholar, Edward Levi, the law's most fundamental process isn't about logic puzzles from a master rulebook. It's actually something way more intuitive. It's reasoning by example, going from one case to the next.
So how does this actually work? Levi breaks it down into this simple three-step dance. First, a judge looks at a new case and sees a similarity to an old one that's already been decided. Second, the judge basically pulls out the rule from that old case. And third, the judge applies that rule to the new case and boom, we have a decision. It sounds pretty straightforward, but the real magic and all the debate happens in that first step.
And this is the absolute key. It means the rules aren't just found in a book, they're constantly being remade. Because every single time a judge decides that a new, different case is similar to an old one, they are, by definition, changing the meaning and the reach of that original rule. The law isn't some static object. It's a living, breathing thing that evolves with every new decision.
To really wrap your head around this, there's no better way than to actually watch a single legal rule evolve over an entire century. So let's track the story of what the law considers a dangerous thing.
Okay, so watch how the definition of danger just twists and turns. It starts off super simple in 1816 with something obvious, a loaded gun. But then, pretty quickly, the courts get nervous. They refuse to apply the same logic to a defective stagecoach because they're worried about opening the floodgates to lawsuits. The category seems stuck until a case about mislabeled poison creates a breakthrough. The rule expands the things that are in imminent danger. From there, it slowly stretches, case by case, from poison to defective hair wash, all leading to a final showdown with the ultimate modern machine, the automobile. And this just perfectly illustrates that moment when the law had to face a brand new world. In this landmark case involving a defective Buick, Judge Benjamin Cardozo famously said that the old rules, the ones made for stagecoaches, just didn't work anymore. The world had changed and the law had to change with it.
So the Buick decision completely shattered that old, narrow category of danger. A manufacturer's responsibility wasn't just for obvious things like poisons and guns anymore. Suddenly, it extended to almost anything that could become a thing of danger if it was made carelessly. From a coffee machine that might explode to, yes, a car with a bad wheel.
All right, so that's how judge-made law evolves. But what about the laws that are actually written down by lawmakers?
statutes and constitutions?
Well, it turns out a very similar process is at play. Judges are still reasoning by comparing examples. The big difference, though, is how much freedom they have to play with the rules, and that depends a lot on where those rules come from.
Think of it like a spectrum of freedom. With case law, like we just saw, judges have a ton of room to rework and reshape the rules. With statutes written by a legislature, their hands are more tied. They're supposed to stick to the legislative intent. The words are fixed. But here's the paradox. With the Constitution, the highest law of the land, judges often have the most freedom. They can always go back to the powerful and often very ambiguous words of the original document, sometimes leaping over decades of other cases to forge a totally new path.
So, right about now, you might be thinking, hold on a second. If the law is this flexible and ambiguous, isn't that a huge problem? Isn't that just random and arbitrary?
The brilliant Justice Oliver Wendell Holmes Jr. had an answer for that. In one of the most famous lines ever written about law, he said that the life of the law isn't pure logic. It's human experience.
And that quote really gets to the heart of this other great legal philosophy, legal realism. The realists argue that law isn't some sterile, abstract system sitting in a vacuum. It's a tool, and it's shaped by all the messy forces of society, history, and politics. Its ultimate goal isn't just to be logically perfect, it's to solve real-world problems and get to outcomes that people can actually live with and see as fair.
So from this point of view, ambiguity isn't a flaw in the system, it's an absolutely essential feature. It's a feature, not a bug. This flexibility is what allows the law to adapt to things like cars and, the internet. It creates these little gaps where new ideas and society's changing values can be infused into the law. It even helps politicians make compromises to get laws passed in the first place. This ambiguity is what keeps the law alive and stops it from becoming some brittle, irrelevant, and totally outdated code.
So let's just boil it all down. We've really got these two competing visions. On one side, there's the myth, legal formalism. That's law as a perfect science, a fixed pyramid of rules where judges just find the law. And on the other side, you've got the reality, legal realism. That's law as lived experience, a dynamic, ongoing conversation where judges are actively helping to make the law.
So if there's one thing to take away from all this, it's that legal reasoning is less like solving a math problem and much more like a deeply human, highly structured, and never-ending conversation about what fairness and justice actually mean to us.
And this leaves us with one last pretty deep question to chew on. If the law isn't some fixed set of rules handed down from the heavens, but is instead an evolving human creation, what is it exactly that makes it just?